grandmother, great-grandmother, mother, Verona Gunn, who was 84 years old at the time that she passed away. Verona was in the back seat of her family's vehicle when two police cars from the city of Chicago actually collided in an intersection, and one of the cars landed on top of the Gunn family vehicle. After about 30 minutes of severe and agonizing pain, Miss Gunn tragically would come to pass away the following morning. And so we reached out to jury analysts because after litigating the case for approximately 3.5 years, the city of Chicago on the eve of trial finally decided to admit liability in the case. However, in the months leading up to the trial, we had no idea they were going to do that. So we had kind of a fork in the road that we were going down on how we were going to be preparing our case. On one hand, there was a significant amount of liability evidence that we knew would benefit us. Cops failing to respond to calls coming over the radio, them refusing to call off their high-speed response to a crime scene that had effectively been neutralized. And we knew that if that evidence came in, it would be very favorable for us. We also knew that there was a possibility that the city could admit liability. And if that were the case, a significant amount of favorable evidence for us would be kept out by the trial judge. And so the reason that we reached out to jury analysts is we wanted to come up with a controlled environment where we could run both scenarios by a large pool of jurors. In the past, our firm has run focus groups in person with a couple dozen individuals. In this case, we wanted a broader swath of people. And so jury analysts was able to get hundreds of people from our potential jury pool to listen in on the factual scenario that we developed. We had a ton of flexibility because of the way that jury analyst works, in the way that they present the facts and then follow up with those facts with very insightful questions that really home in on the most important aspects of the case. And so the way that we ended up designing our focus group with them was that we started as if all of the evidence was going to be kept out. Once the cows are out of the barn, you can't get them back in, right? So we started by putting in all of the damages evidence, hearing what the jury had to say. After each fact was introduced, jury analysts got us back how favorable or unfavorable that fact was, and an overall assessment of where people were going to come down. Were they plaintiff-centric? Were they defense-centric? And as we proceeded through the 5 or 6 questions that we had, we saw a gradual progression of how the jury was going to come down, ultimately resulting in a damages figure so that we could assess, okay, what is the value of the case without our best pieces of evidence. We then moved ahead and we introduced that liability evidence to the prospective jurors, and we saw what happened. How much of an impact would this evidence have on the damages awards that we were going to be seeking? Because we knew we could prove liability in this case. We didn't have too many concerns there about liability, but we had to know what is the value of this case. One thing that I didn't mention in the initial fact breakdown was that unfortunately, Ms. Gunn had a history of dementia as well as Alzheimer's. And so the city of Chicago was trying to use that as a massive sword against us, trying to devalue and diminish the loss of Ms. Gunn's life to her family. And so we wanted to see what would a jury of her family's peers say about the value of her life and what it means for her family going forward. And I can report that the findings that we had from jury analysts showed us a range of damages. I believe Chris or Keith can correct me if I'm wrong, but I think the projections were somewhere between 5 and 8 million. And the eventual result we got was just a little bit below that 5 million number. We ended up recovering 4.75 million on behalf of Ms. Gunn, and another 180,000 on behalf of some of the individuals in the car who really their claims were more derivative of the wrongful death count. And so we got what we thought was a great result on the case, helped in large part by the information that we gathered from jury analysts just a few weeks before they were able to turn it around for us and really give us, one, information on the value of the case, information that was important to the potential jurors, and then what the best juror profiles would be when it came to, Tony conducting a very, very difficult voir dire process, which I'm sure he can go into in a little bit more detail. But it was something a bit unique even for Cook County and how we had to do voir dire. But the information that jury analysts gave to us was so incredibly impactful in helping us obtain what we thought was a great result on behalf of the family.
I mean, I think the case that we most recently, I think, went to trial with using jury analysts involved a teenage boy who was on a school service project that was impaled by a partially cut bamboo stock. It impaled him through his rectum, and it actually sort of skewered his bladder. And he had to be rushed to the hospital. Fortunately, his life was saved, but he had some complicating long-term effects of the injury. And our view, similar to, I think, Bryce and Tony, was trying to figure out, we have our own assessments in our own heads of what we think the case is worth, what we think the strengths and weaknesses might be. And, we come into our own confirmation biases as we go along through a case about, what's a jury really going to love about our case and what are they not going to love. Jeffrey and I, for example, had Jeffrey thought that the long-term damages involving his sort of reproductive health were going to be of higher value to the jury. I thought in some ways that his post-traumatic stress was going to be of higher value to the jury. But either way, we were still trying to find what is the number or what is the result that we can best statistically predict so that we can help advise our client on A, whether to take a settlement, B, whether to go to trial, and how to essentially conduct the case from there. So using jury analysts, I think we started pretty early-ish. Our first, I think, survey and panel that we did was probably 6 or 7 months pre-trial. And that was very helpful to us because it still allowed us time to be able to adjust or respond to some of the respondents and some of the information. And the data that we received not only sort of gave us the analytics, which is, how many percentage of people, similar to what Bryce was saying, what percentage of people thought this was a very good fact for the plaintiff, or which percentage of people thought this was a poor fact for the plaintiff. But what I have found most helpful is the participants are provided the opportunity to essentially jot down their own thoughts or their own feelings or their own impressions in response to some of these individual fact questions or individual facts that are provided to them. And if you read them through and you compare them to each other and you compare and contrast, as a trial lawyer, you can start to pick out some themes, some consistencies, some ideas that even though these jurors, in a normal focus group, and the focus groups that we've done in the past and still do in some sense that are different than the big data stuff, we have a group of people who come to maybe one consensus of an idea. You may have one person volunteer an idea of what the theme should be or what a good analogy is or what a good metaphor is, and then you'll find others sort of embrace it or adopt it and repeat it. But that doesn't help me as the lawyer understand whether all of those people felt the same way walking into the room. And the way that I view the big data or the surveys with jury analysts is it allows us to understand at a higher rate, at a higher number, at a statistically significant number, hopefully, where are people when they walk into the jury deliberation room? Because if we can narrow the gap between how far apart these people's beliefs or perceptions are about a case when they walk into the jury deliberation room, the amount of variance or the amount of, how far off they're going to go off of that narrow gap of difference is much less than if you have two people walking into a jury room thinking completely different things about the facts that you just presented. And so when we get these, when jury analyst was able to provide us these little snippets of information, we're able to see, things like they never should have been there, or, why were they allowed to be there? And these ideas and themes that we were able to incorporate in our case. And for us, in Virginia, we're still a contributory negligence state. So 1% of liability on the part of our plaintiff means 0% of recovery. And so the attribution of fault, as it's done sort of in how we've worked through with jury analysts, sometimes can scare people, which is, you can have people attribute liability to a plaintiff. In this case, I think we were close to 15 or 20% for the plaintiff. Chris, correct me if I'm wrong.
I think about that, yeah.
And, in talking to Jeffrey about it, we sort of tried to dissect those numbers and say, okay, is that 15 to 20% of people based on their comments saying that they think our client's responsible, that they think our client was negligent? Or is that 15 to 20% of people that are saying that they don't think the other side is responsible, that they don't think that the evidence against the defendants was strong enough to hold them responsible? And working with Chris and the group, we were able to sort of tease some of those data points out so that we could better decide how to proceed to trial. And the long and short of it, in terms of how it affected the end result, is, that the variance that we got in terms of the damages model, at the end of the day, helped us have candid conversations with our client as we received settlement negotiation offers and settlements as we inched closer and closer to trial, to not just say, hey, I think you should turn this down because I have a feeling that it's going to be, the verdict is going to be higher than what they're offering. We had numbers. I think we ended up doing 2 different survey groups, and we had over nearly 300 different participants in our case that came back with a model of damages that was higher than what their last offer was. And so we went to trial, and our verdict was higher than their last offer. So in that way, it sort of helped advise us on how best to handle not only pretrial negotiations, but also how to frame our case in front of the jury.
Chris, I'd love to add something that, both Bryce and Kevin, touched upon, where the data, where the predictive analysis was so helpful to us, if I may.
Of course, please do. Yeah.
Yeah, I think what was so important in our case, it's called we call it the gun case, but it's with 2 N's. So we're not talking about, an actual weapon. We're talking about their last name. It's GUNN. And Kevin, you said it, it's we're using this predictive, analysis to determine whether or not we take a settlement. Bryce was being generous when he was talking about our case, but, when we talked about the amount, which was 4.75 million, we didn't know whether or not we should take or push a settlement for our client, because not only of her age, but because of her dementia, which the doctors characterized as severe. Were jurors going to value the life of an 84-year-old retired woman with 3 grown children in their 50s and 60s, any sort of money that would really equalize what we felt was the value of life, as opposed to putting her into a matrix, which is what the city was doing? So we felt we owed the family that duty. And, when the city starts offering, $1 million, $1.2 million, we have the right, we have a duty as lawyers to know whether or not we should pursue a higher settlement than $1 million and push as far as we can and get the most, or just say, all bets are off the table. We're going to take this case to trial. And that's what we were able to do with the analysis that we got from the gun case. We knew, or at least we felt very strongly, that we should not take the settlement or pursue it, because what ultimately happened was there was 30 minutes of conscious pain and suffering that we were able to prove. This case, with the help of jury analysts, turned out to be the 3rd highest recovery ever in Illinois for an octogenarian. And so, we're very proud of that, because what does it do? Well, it's not about us. It's about setting the bar higher on the value of life. and equality, right? That's what our story turned out to be as a result of the data that we got back from jury analysts, was the equality of life. And that's what we kept pushing. We continued to push that story. Equal value, equal rights. We're all equal in this room. We all have the right to a trial. We all have the equal right to the same value as anyone else.
No matter what the age is.
Exactly.
Because I think a lot of attorneys seem to say, oh, that's a hard case because the person's older, or he's got all these preconditions and stuff like that. And
Oh, she's old. And yeah, I mean, she doesn't even know that she was alive, right? That's probably what you would hear. She wasn't even aware. Yeah, she was conscious, but was she aware, right? But we were able to elicit that testimony, not only of conscious pain, but also the awareness by her grimacing or her reactions. And because I don't want to say fortunately, but somebody, one of the family members rode in the ambulance with her. So we were able to get that testimony out. And we were able to we got over 4.5 times what their offer was, which was highly significant. And obviously we were very proud of that, because we were able to establish a value of life.
was that a record breaker, by the way? It seems like it was.
Third highest in Illinois.
Wow, congratulations.
Yeah, third highest. And let me tell you, the first two cases, because we know the first two cases, I believe one was a med mal case and a products liability case, but one had about 9 months of survival. The other one had 2 years of survival. So big difference, big difference. So that's why we feel even better about the result we got for our clients, because we only proved 30 to 35 minutes of conscious pain and suffering.
Well, thank you for sharing that. I've got a question for Kevin and Bryce now. In your guys' experience with colleagues who are more resistant to change, what factors do you think are behind their concerns about integrating new technological solutions, kind of like data analytics that we just spoken about, into legal proceedings? And then following up from that, how do you feel we can ensure that senior partners and other members are able to understand and effectively utilize predictive analytics in case analysis? I don't mind who goes first.
What's your definition of senior partners? People that are senior or people whose name is on the door?
I'll leave that open to interpretation. I'm going to plead the fifth on that one.
I heard the word.
I can start off, and Kevin, if there's anything I missed
Sure.
or you feel differently, but I think as lawyers, so much of what we do just in the courtroom, being in front of a jury, it's a social experiment, right? And there's something to be said for just your own perceptions of seeing people's reactions to certain facts and how people respond to new information. But I think what is most important and what really drives big data is the big part of it, right? You're talking about taking 10 to 20 times the amount of people for a fraction of the cost and getting so much information. I mean, Kevin brought up earlier the information that this type of process generates in the form of individual responses. Tony and I combed through that for days, looking for that exact kind of information that Kevin referenced. And it's the kind of thing you just can't get from even a 24, 36 person focus group, because so many people end up getting poisoned, not literally, but with the information from other jurors. They're going to hear something and say, oh yeah, that makes sense. And you don't have that baseline that Kevin talked about of what were these people thinking when they walked in. And I think that there's something to be said for a jury when they're actually sitting in the jury room having those kind of conversations. And that is the reality. People give and take, and they take things that they hear from other people. But what we're trying to do with this is figure out who are the best people to have in that room in the first place. And for us, that's what I'm really driving a lot of people at our firm to start using this kind of technology with, is because it's not about, who can lead the jury once they're in the room and what's going to happen once they're behind the doors. It's who do we want to send into that room to make these decisions? And for us, we have such a diverse group of people in Cook County. I mean, it's one of the largest metropolitan areas in the country. And because of that, we have such a broad swath of people that we could get onto a jury. And so knowing ahead of time with, 300, 400, 500 people, who the best jurors are, what the best answers to certain questions are, what the best background demographics are. Those are the things that, we can rely on our instincts as lawyers and our years, in some cases, decades of practice. But there's something to be said for taking advantage of what this kind of technology can provide, which is just an overwhelming amount of information in a good way, and being able to use that to curate our arguments and our voir dire, and ultimately our entire case strategy to maximize value and recoveries for people that are traumatically injured or killed.
Yeah, I think I think Bryce's point is well taken about, we're trying to figure out the baseline, and we're trying to do it with as many numbers as possible, because to Bryce's point, and a little bit different for us in Virginia mostly, is we're trying cases in different cities and counties every time we go to trial practically. And so for us to feel like we have a good sense of each venue or jurisdiction is being too kind to ourselves, right? I think we have to humble ourselves. And to Jeffrey's credit, although he is senior to me, he is open-minded. So in conversations with Jeffrey about the big data and the rest of our team about how we're going to use it, I think what Bryce pointed out, that him and Tony go through it for days, is similar to us and how our team works. And what I would say to people who may be resistant or who are trying to figure out whether this is for them is to say, if you're looking just for the end result and to just say, what's a jury going to do? This is going to provide you some value. But if you're willing to go through the detail and actually absorb all of the data that's being provided, this is really for you. Like if you're a little bit of a nut like we are, and it sounds like Bryce and Tony are, and really trying to get into the weeds of why people are making these decisions and what they're thinking when they're trying to come to these results, then more data is always the answer. It's like all pub is good pub. At some point, all data is good data, because the more you have, the more you can sift through it. And in talking to Jeffrey, and I wouldn't even call it convincing or swaying Jeffrey, the conversations were mostly about, well, what's the cost difference? Sure, we have to consider what those things are, but what's the value add that we're getting from the big data as compared to a normal focus group? I think for us, the question isn't whether we're going to do focus groups. The question is, what's the method that we're going to use to do them? And in speaking with Jeffrey and going through the initial processes with you guys, I think seeing that there is a higher number of data points, there's actually information that we can take from it to be able to use, rather than just a figure or a number. I think those 2 points, and Jeffrey can speak for himself, but I think those 2 points were helpful in having those conversations about going in this direction.
Cool. Well, thank you both for sharing that. I've got a question now for Jeff and Tony. Bryce and Kevin have both said, you're open-minded. We wouldn't be having this conversation if you weren't. You're both at least partial converts to analytics. I'd like to hear from both of you guys. What was your case prep process like before using analytics? What made you try analytics for the first time? And also, why do you still use them now? I'm obviously something positive has happened for you to continue using it.
Tony, I'm going to take a swipe at it, if that's all right.
Please.
I'm a recent convert to analytics because of what I saw and what it could do and the kinds of numbers it produced for us. Old school focus group, 15 to 30 people. I've used 50. But one of the things that changed my mind, one, was the cost. And not everybody has $5 million cases. You have a $5 million case, you're going to spend $50,000 on a focus group, and you're not going to think about it. You're just going to do it. And you're going to get whatever information that you can get from your focus group and try to apply it. What I found was, one, the cost meant that you could do it on something less than $5 million case. You could actually do analytics on smaller cases, get some information. But it was the overwhelming amount of data that we received. One of my responsibilities in lots of our cases in our office is to negotiate with the other side. And you negotiate in blindly. You know, we think the case is worth 50 million. They think the case is worth $1 million. Well, what do 150 other people think that are looking at the same fact, same injury, age of the plaintiff, color of the plaintiff, sex of the plaintiff? What are the things that are catching their attention when they put a number? And looking through those individual sentences, which is what Bryce talked about, going through those lines that the jurors comment on where they haven't been poisoned by other jurors. That's a great place to find themes. You know, what are we going to talk about to this jury, and how are we going to theme our case? They give you more information than I've ever seen. And so after we did it a couple of times in a couple of cases, I became an immediate convert. I think the first thing that converted me was 150 people have replied to the questions, and now we have data. The flexibility of being able to take the questions and add a new question, change the approach. We have a case that Kevin's going to trial in a month on. Who are the primary defendants in a 4-defendant case that we should focus on? Why do they think this defendant is worse than the other defendant? Was the plaintiff responsible in any way, which of course is a Virginia problem with contributory negligence. But when you look at the sheet and you go, 3 people out of 150 thought that the plaintiff was at fault, you are comforted when you reject a multi-million-dollar offer. When a focus group or the analytic data comes back and says 50% of the people think the plaintiff was at fault, you've got to reduce your expectations. Every case that we try, we have to know where we can push and where we can't push. Certain cases are bad on the facts. Certain cases are bad on appeal because the law is bad. You may get a big verdict, but who cares if you have a big verdict and if you're going to lose it on appeal? Learning your soft spots tells you whether you can keep on pushing. And so I think that Bryce and Tony, in their $4+ million wrongful death case, got the impression from their data that, wait a minute, we're undervaluing the life of an elderly person. And so what I have learned in our analytics is that my numbers are Jeffrey Breit's numbers from 42 years of practicing law, but is this what other people think? Because I'm not normal, I'm an old guy. And I have a different perspective on every case because I'm a lawyer and I'm senior. And so looking at young people on an analytic group and knowing their age and seeing what they think has been very, very surprising to me. It has made me go, okay, what I know or what I used to know isn't the way people think anymore. Let me see what these young people think. What do the women, black, white, what do they think about a case? What are their comments? Because I always go back from the comments to the people that gave them to see what kind of person this was. From the limited data that we have, at least I get some idea. And so I think that the new world is, we're never going back to the old world. You can do a focus group and get some ideas, but I don't think it touches what the analytic data that we get now in these cases, honestly.
That was very insightful, Jeff. And, I'll say this. I just started watching the show Succession. I'm new to the show. And I watched an episode yesterday where Logan Roy used a term and his daughter Shiv said, "Dad, we don't say that anymore. We don't refer to it like that." And you hit the nail on the head, Jeff. As much as I'd like to think that I'm progressive when it comes to data, computers, electronics, and apps. Well, I'm not 20, I'm not 25, I'm not Kevin and Bryce's age. I don't have the experience that they have, which is where the richness of our jurors are coming from right now within that age group. They're less likely to be jurors like me, the way that I would think or the way that I would refer to something or say something. And what I found in the jury analytics that we got from the gun case, the most helpful tool that I got, because we had an admitted liability case, because I knew we were trending that way. For me, it was the cloud bubble. Right. I took that cloud bubble, you know, in the different scenarios that it was laid out. And that's where I constructed the story. And Bryce had mentioned earlier that our voir dire was challenging. It was a challenge because I had never voir dired 48 people at once. That was the judge's way that she picked a jury. She told me that I had to voir dire 48 people at a time. She goes, oh, you can voir dire them in panels of 1 or in panels of 12. I don't care how you do it, but you're getting all 48 at once, and you're getting, I don't know, what she give us, an hour 15, something like that.
An hour, yeah.
So 48 people in 1 hour, that was very challenging. So there were a lot of group questions, but here's where she did give me leeway. She gave me leeway in indoctrinating the jury a little bit. So I was able to really get out our story using a lot of the words that I had threaded from the cloud bubble. So I was using those words and telling the story. Ladies and gentlemen, what if you knew this about the case? And I was using those words from the cloud bubble. And so I thought that was very effective because we didn't have a lot of time. And the time that she gave us in between for our cause challenges and our peremptories were literally, without exaggeration, she would say, okay, you have 3 minutes to decide. You have 7 minutes to decide. And so it was one of the quickest juries I've had to pick where I've had time, where I was given any time at all, as opposed to federal court where you get almost no time. And so without having been able to indoctrinate the jury and let jurors speak to some of the major issues, such as her age and her race, and whether or not all people should be treated equally, and the value of life. And we even talked about the Constitution and equal rights. Without having been able to do that during voir dire, I don't think that we would have had the jury, we would have wound up with the jury that we had.
Cool. Thank you both for sharing that. I guess my next question is for everyone here. What is your current understanding of emerging strategies such as predictive data analytics and AI? And how do you believe these strategies can be applied to legal proceedings? Like, analytics kind of as a whole really simply means analysis of data, which can be as basic as I've had X number of successful cases and recovered Y millions of dollars for my clients. As simple as that, really. But obviously, you can go a lot more into it. So yeah, how do you guys kind of see predictive analytics, artificial intelligence? How do you think they can be applied within kind of your work and with legal proceedings?
Let me answer this, and my time is running short anyway.
Sure.
My knee-jerk reaction is that I hope it doesn't, because I don't want the practice of law to become a predictive analytic nature. Injury equals this much when you have this age. That's why we're trial lawyers. We don't think it should be predictable. We don't think that we fit into a graph, and because you are of a certain age and a certain injury, you collect this kind of money. I'm not sure it helps us on the predicting the future, but I think it is invaluable in the present because of the different way people look at facts. And so every case has different facts. Every case has nuanced facts, both on injury and liability. And listening to, instead of 20 people, 150 or 300 people, listen to your facts and make their decision is helpful in predicting what your verdict may be, but it's not predictive of the future, and I hope that it won't be.
Yeah, and
absolutely.
I just want to interject one thing there, because I know you were talking about, or Tony was talking about, how this audience may be different. And this, before Jeffrey has to leave, this audience that I'm talking to may be different, and the way I communicate with them, obviously my words, my messaging is going to be different. And that's a good transition for us to talk about how we are right now discussing an opportunity for async, what we call groups. And those are a new method, just because I know you were asking me about that earlier. How can we communicate with people when they are on these devices, the mobile devices? And if I'm used to bringing them into a, I don't know, mock jury, or if I'm bringing them into a focus group, live one, but what if I was able to get them on their devices, and they could actually answer questions at their leisure? So that's what, basically that does. In fact, I think, Kevin, you could probably talk about it a little bit too, in terms of the Reddit style.
Yeah, I call it Reddit style, but at risk of talking for everybody, I think at the end of the day, as lawyers, as trial lawyers, we're trying to make the best decision possible in each circumstance. And a lot of times we're only faced with that same decision in that salient moment in time once, right? And so you're just trying to make the best decision. It may not result in the best outcome. You can make the best decision possible with all the data and information available to you, and you can still lose your case. But the ultimate objective, at least mine, is, I can't point to the gray hairs on my head to convince a client that I know what I'm talking about, right? I can't point to the gray hairs on my head to tell the client, I've tried a case like this 15 times and this is how I think it's going to go. I need to be able to, rather than just shooting from the hip, be able to provide them some sort of comfort, provide myself some sort of comfort, to feel as though when I put my head on the pillow at night, I'm making the best decision possible for my client. And whether it's whatever method we do that, we're trying to just collect dots, always be collecting dots, A, B, C, D, and then always be connecting dots, A, B, C, D. So the more dots you collect, the more dots you can connect. And for async, in my understanding of async, and you guys can correct me if I'm wrong, but we're almost creating a forum panel or a Reddit panel that you guys have created, where it allows us to do what I think Jeffrey and Tony were talking about, which is sort of cater the case and respond to the information as you get it, to be able to get more specific factual information. So let's say you get a couple people that say, hey, I think this is an important issue, and you haven't really explored that issue in your initial focus group. Well, you may want to explore that third or fourth defendant that Jeffrey was talking about, that all of a sudden is important to these jurors. And rather than having to, all right, let's go out and let's find 15 more folks, and let's schedule this out for another 3 weeks, and let's make sure we can get them all on the Zoom at the same time, and let's spend all this time and process trying to put this together just so we can get 3 or 4 or 5 or 6 people to tell us what they think. If we can get the same data and information immediately, or soon, or close to immediately, or very quickly from these folks, when it's convenient to them, at the end of the day, we're getting the same outcome, if not better, but we're getting it faster, we're getting it more reliable, and we're able to adjust to the information more quickly. So I don't have to have, 6 months to do thorough, focus group prep. I can respond to a fact week after week, every bi-weekly or whatever it means, asynchronously, so that people are constantly responding and constantly giving us feedback.
If I could add on to that just a little bit, I thought that was spot on. The way I see it is we have to meet our clients where they are at this point. And Tony referenced this a little bit earlier. Jurors are getting, younger comparatively, relatively. And the culture and the way that information is gathered these days it's a TikTok culture, right? These are 30 to 60-second videos that people are watching. They're quick ads. They're not sitting down anymore. You look at the average Netflix show, Tony referenced Succession. I mean, that's really the extent of people's attention span these days. And so who are the people that are actually going to commit themselves to a 3-hour full day focus group like what we're traditionally used to? You bring a system like async in, and it allows the jurors to come to us with the information when they can provide it. The focus groups in person that we've run recently, what I've seen is you're not getting the typical jury pool. Okay, the people that are going to get the jury cards and going to show up for jury duty, it's everybody. But the people nowadays that are going to come into a focus group and offer their time up, at least from what I've seen, is not that full representative body. Okay, it's now what we're talking about with an async type situation. You could have people that are working remotely, people that are working, maybe those tough jurors that are tougher to read, middle class, upper middle class, wealthier individuals who you may not be able to avoid getting on your jury. They can sit down at a computer and have the exact same conversations that they would ordinarily have in a room with people, but on the computer. And so we unfortunately didn't utilize the async in this last trial that we had. But I think with the way that things are going, I can guarantee we'll use it in the next trial that we have. Because again, younger individuals, the COVID pandemic, people are more accustomed now to being in front of their computer, sitting at home and taking in information, giving out information, rather than spending a half day or a full day in a room full of strangers. I don't think you're going to get the representative information that we think we're going to get. The way I see it, maybe a traditional focus group or even a mock trial is great practice for us to get our ideas out there. But if you want information, async and this big data, that's the way to go, because that's going to give you the broadest amount of information that I think you can get. And I'm really looking forward to using it on our next trial to see kind of these conversations on top of the big data that we get on the front end from people.
Chris, can I interrupt you?
Absolutely, go for it.
I have an hour and 15-minute drive to
Sure.
30 students who are going to be waiting for this gray-haired gentleman.
I've got a 5:15 cutoff too, at least.
Bryce and Kevin are the new brains. Tony and I are old brains, but Tony, you stay here and help. But I have to leave or I will not make it. And I'm probably not going to make it now on time. Ask me again, but give me a little more time. Kevin, I'll talk to you later.
See you, Jeff.
See you guys.
Cool. Thank you, Jeff.
Annie.
Annie, do you see any downsides? I mean, you're taking definitely an observational view from now on lately. Do you think you guys, or anybody, I should say, anybody see downsides to that? Because I know some people feel like there's keyboard warriors and there's other people who change their personality when they go to trial, right?
Downsides to async.
Mm-hmm.
And you're saying just by, yeah, I mean, there's downsides to everything theoretically. I mean, I think you're not getting groupthink in an asynchronous focus group or big data. And at the end of the day, our verdicts are the result of groupthink. So in some ways there is that downside. But I think to Bryce's point, it's which downside are you looking for? If you're looking for a representative population of the people that are likely to get the jury slip, you got to meet them where they are rather than trying to compel people to come to you, which probably limits the pool of people that are going to respond. So maybe you get a couple keyboard warriors, but those keyboard warriors may not be as statistically significant if you have 150 people responding compared to 2 or 3 people showing up in a 9-person focus group that want to control the conversation.
I guess another important, 2 points to kind of follow on to that are that actually filtering and vetting the data that you're collecting is very, very important, of course, so that, the quality of data that comes in is going to completely predict the quality of the data that you get out at the end of it, for sure. And to kind of follow on to of Kevin's point of groupthink, the whole purpose of the big data is to change the group in the groupthink. You want to be getting, those good supportive jurors in who are going to all be in agreement that your case is good. So that's kind of the almost preemptive step to the groupthink, if that makes sense.
Well, we recently used it on a toxic tort case, and I thought it was very important because it dealt with a lot of science. Typically, yes, personal injury lawyers, do they deal with science? Yes, we do, but it's usually in medicine. This dealt with a lot of chemistry. It dealt with a lot of subject matters that were very complex and dealt with formulas, and it dealt with issues that juries typically don't encounter. So we threw a lot of data into the bucket with jury analysts, and we got a lot of data back, which was extremely helpful, because I got to tell you, we probably spent 4 or 5 months working on our opening statement. We started working on our first draft of opening statement in July, I believe, of 2022. And the trial was January 9th. Now it resolved on the day of trial. And it was a global resolution of many cases, but we had one specific case that was going to trial. And on that day, that's the first time that we told the judge that the case had settled, because it had settled over the weekend. So in that case, I think it was particularly helpful in what we would call a complex injury case.
Okay, well, thank you very much for showing that, Tony, and thank you very much for joining us. And
thank you, everybody. Really appreciate it. Take care, everyone.
Thanks, you too. Okay.
Can I follow up on one thing with what
Go
Tony
for
said?
it.
Because it was such a complex case, this goes back a little bit to his thought bubbles and these themes that you gather from these comments you get. With such a complex case, you would think that, oh my God, this case is so complicated, you're going to get a million different responses on what's important. But what you actually find when you use big data is you do see these common themes weave through everybody's answers. The defendant point Kevin raised earlier is a great one. Same thing, though, goes for things like witness order, testimony, experts, subject matter that you're going to be talking about in the trial. What are the most important issues? What do people not care about? Kevin mentioned confirmation bias. You live with a case for 5 years and you imagine certain things being the red light. That's the issue. That's the big thing that we need to focus on. But you give somebody something where they look at it for 5 minutes, 5 hours. You're in front of a jury for 5 days or 5 weeks. The important issues to them, as people that are not as familiar with the case, could be totally different. And we've done these before. And on that case, some of the issues that we thought were going to be a major factor and things that we would have to address in a complicated way and find a way to articulate it, the jurors just kind of glanced over it. They jumped right over it. And it was like, no, that's not an important issue, lawyer. You sit there and you draft your motions and you run your evidence and you put on your witnesses and you're talking to all these experts, and the experts are telling you what's important. You're telling them what's important, but then the jury's sitting there saying, no, it's really A to B to C, and it's not A to Z, all of these factors. It's really just, it narrows it down. So I would actually push back on, big data and it being too much information. I think you'll actually find that it helps consolidate and condense your case stories and the information you're presenting.
Yeah, I think you need to at least have a rough-ish idea of what it is you want to look at. Like, the general way I look at it is big data is kind of hypothesis generation. So like, are the jurors going to like my case? Roughly how much money are they willing to award the plaintiff? If you don't, but you still need to have, a basis of that, be it, making your original complaint a bit more neutral and presenting that. But just starting off with, I don't know what I'm looking for, is not going to give you very much. You need to have at least a minimal idea of kind of, at a minimum, those 2 questions, I guess. Once you then know a bit more, in my mind again, and this certainly isn't the only way, that's when, for instance, the asynchronous focus group would be really good at, say, hypothesis testing. Like, you know that this fact is important, or maybe this fact is kind of quite divisive. If I present it in manner number 1 or manner number 2, how do people react? Which argument do people prefer? And so you can kind of reframe your arguments that way, if that makes sense.
One of the issues that, as you said that, Chris, the thing that came to mind in the gun case was we had a video of the crash that we thought was bad, but then we also had kind of a telling of the story of what happened leading up to it. We had some audio and video. We also had testimony about what had happened and how it violated policies. And we wanted to know, was the video, was there a risk of overplaying the video? I think sometimes as lawyers, we focus in on what we think is the best piece of evidence, and we overuse it. And we were worried about that. We wanted to see what would happen with these jurors. They have the damages information. Like I said earlier, we came to kind of this fork in the road. Do we go with just the video? Do we go with the fact pattern? And then ultimately what happens when you merge the two? And again, big data, if you're sitting in a focus group and you're trying to run that down with people, you're going from a group of 12 to 6, right? 2 groups of 6, or you're going from 24 to 12. And with this, you're going from a group of 200, 300 to a couple hundred people in each group. You're better able to test these kind of things and actually get a real, what I think is a real, like Kevin said, a statistically significant result, rather than just, oh, you found 5 random people or 6 random people who happen to think this is better. I don't feel as confident in that, in going to a client and saying, hey, this is what I found, this is what I determined. Well, how many people is that based on? And how sure are you of those results? I can be confident that we have 100 people, 200, 500 people. I can rely on those results in a really, really meaningful way.